Okay, this is video lecture number 2 for the makeup class for September 12th in evidence. I want to start this video with a really interesting question that was posed by a student a few years ago in my class. So, talking about this issue where a criminal defendant has put on a positive character witness to testify to his positive character in the form of reputation or opinion testimony. And then now we know the prosecutor can ask about past acts on cross-examination. So let's say that's what happened here, and the prosecutor gets up and asks about a prior arrest. Asks this question: did you know that the defendant was arrested for assault 2 years ago? And let's say that the character witness says yes and starts to explain more about that, but the prosecutor cuts the witness off and says no further questions. So the question is, may the defense attorney now, redirect? Can the defense attorney get back up and ask the character witness more about that prior arrest? So my initial instinct on it was that, well, no, maybe the defense attorney can't do that, because wouldn't that veer into the territory of actually discussing whether the act in fact happened or not, what the facts were, and so on. And remember, the point of the question of these cross-examination questions by prosecutors is only supposed to be to test the witness's knowledge of the defendant. Now, the truth is that there's very sparse case law on this. I'm going to talk in a minute about a couple of California cases that I've found on it. But one thing to keep in mind on this question, it's a really interesting sort of academic point to argue about. But the fact is that defendants very rarely take advantage of the exception in Rule 404A2A to put on a positive character witness, for the exact reason that they don't want a prosecutor to be able to cross-examine and put before the jury a question about some past bad act that otherwise wouldn't be admissible. But like I said, as an academic exercise, if we just look at the issue of the character witness's knowledge of the defendant, if the prosecutor asked this question, did you know the defendant was arrested for assault 2 years ago? And the witness says yes, and the prosecutor and judge then cut the witness off. Why wouldn't it be acceptable for the defense attorney to redirect on that arrest issue and make an argument that further questioning on that also goes to the witness's level of knowledge of the defendant? And I will say that commenters on evidence, treatise writers and such, have basically agreed with that position, that it should be allowed for that reason. Now I'm going to, in fact, add to my hypothetical scenario that in this arrest that happened of the defendant that we're talking about, that the defendant was actually acting in self-defense, and so he wasn't ever charged, let alone convicted of the offense. And let's imagine that his character witness knows all about that. So the question is, well, could the defense attorney ask that witness on redirect something in this form? Isn't it true that the defendant wasn't actually charged at all with assault from that incident? Now, first of all, this is a leading question, so I think it might not be allowed, because remember, this is the defense attorney asking the defendant's own witness on redirect a question, and normally leading questions of your own witnesses aren't allowed. So it could be disallowed for that. Plus, also, the form of this question, I think, could be construed as asking about the truth of the matter and not about what the witness heard. So if a prosecutor objected to this question on redirect, I think it might be sustained. But then I was thinking, well, maybe the defense attorney could just ask instead, could you tell us what else you heard about that arrest for assault? Now I'm thinking, along the lines of what commenters have said, that it might be and probably should be allowed by a judge. The witness could then, for example, say, well, I heard that the other guy attacked him first, and even though he was arrested, they didn't charge him once they found out what really happened. Of course, the prosecutor is probably still going to object, but the defense attorney could then make the argument. This question just goes further into how well the witness knows the defendant or knows the defendant's reputation, and this would not be impermissible extrinsic evidence. It's not putting on a new witness just to talk about the arrest. It's not putting on new documentary evidence to prove something about it. It's just redirect questioning of a witness. Now, the common law definitely was unclear on this. And, I found a couple of cases, both California cases actually, one from 1972 where at trial, actually, the judge allowed redirect questions similar to what I just suggested, but the defendant was still appealing on the issue of whether the prosecutor should have even been able to ask about the prior act at all. So the defendant had gotten to clear up the nature of the prior arrest, but was still appealing because of the past act coming in. And the appellate court there said, no, it's allowable to ask character witnesses about past acts, and besides, any damage was cured by the judge allowing redirect. And it's interesting because the court in dicta there actually said it probably would have been better to just give the jury a limiting instruction, but we're not going to reverse here over that. So not exactly a great case for defendants. And then there was a 1976 California case where a California appellate court flat out said that it was not required to allow redirect in fact, it was another case with an arrest, and that it was perfectly allowable for a court to not allow redirect questions on the disposition of an arrest. So judges seem reluctant, I guess, to allow redirect in this area. I mean, of course, when you think about it, a defense attorney is going to have to know in advance that something in the defendant's past is going to be brought up. Certainly would have to know in advance what a witness might say in response to that kind of question. It was interesting, in some of my past searching, I actually found a PowerPoint slide from a former adjunct professor at Hastings here. He's actually the current sitting Alameda County presiding judge, Judge Morris Jacobson. And on his PowerPoint, which I found online, he actually says defendant is precluded from disproving the prior bad act or explaining the circumstances surrounding it. Now, I think that really seems like a jump in logic on Judge Jacobson's part. He basically was saying, well, the material issue there is just testing the credibility of the character witness, and the probative quality of the testimony is what's important, and it's not important whether the defendant committed the prior act. So therefore, the defendant can't explain circumstances around it. But anyway, for reasons I already said, in my scenario that I'm using in this hypo, the defendant wouldn't be trying to disprove the arrest happened. That was the bad act the prosecutor asked about. The defendant would be trying to rebut the inference the prosecutor is trying to make, that the character witness didn't have good judgment with regard to assessing character. Now, interestingly, Judge Jacobson was a career prosecutor before being appointed to the bench. So if you appear in front of him, I guess you should know the type of questioning I'm mentioning here just now is not probably going to be allowed. On the other hand, Judge Jacobson has been admonished twice by the State Commission on Judicial Performance. On the other hand, they made him a presiding judge. But in any event, I and other evidence colleagues, as an academic exercise, do think that this kind of redirect should be allowed. But I guess that's in possibly the academic perspective versus the career prosecutor turned judge's perspective. Now, this is not something I'm going to test you on. Also, I sincerely doubt that any of you who want to be criminal defense attorneys or prosecutors will have the occasion to come up against this. You defense attorneys in the class probably will never put on a positive character witness for one of your clients, or if you do, it'll be very rare, because the conventional wisdom is that you shouldn't do this if there's anything at all that could come out on cross-examination. And most criminal defendants have things in their past that you don't want the jury to hear about. Okay, moving on. I want to fairly quickly now go over these last few sections of Rule 404 that aren't really covered in any cases in the book. They are included in a couple of the hypos in the book, though, if you looked through those. So first, let's look here at 404A2B. Now, 404A2B is the second exception, okay, for criminal cases to the general ban on character evidence. So it says that a criminal defendant can offer evidence of a victim's character trait that is pertinent to the case. Okay, when is a victim's character trait going to be pertinent to a criminal defendant's case? Well, there aren't very many cases where that a victim's character trait is pertinent. The classic one where this would happen is an assault case or a murder case in which the defendant is claiming self-defense. The defendant is claiming self-defense and wants to offer evidence that the victim has or had a violent character. Now here as well, if that happens, the prosecutor can then offer evidence in rebuttal to that in two ways that are right there in the rule under small letter I and letter W, a double I here, right? Either offering evidence that the victim in fact did not have the character trait. So let's say the defendant is on trial for assault, puts on a character witness saying that the victim had the reputation of being a violent person. Now the prosecutor can put on another character witness saying the victim did not have the reputation for being violent, or in the witness's opinion, the victim is not a violent person. Okay, so the prosecutor can do that. Or the prosecutor can actually turn the tables on the defendant here and now can offer a witness to testify that it's actually the defendant who has that character or that trait, the same one that the defendant was claiming the victim had. Okay, or both, right? The prosecutor can choose either or both of those methods. Okay, so again, example here. If a defendant in a murder case says she killed into self-defense and offers evidence that the victim had a violent character, okay, puts on a witness saying the victim had a violent character. Now the prosecutor can offer evidence that the victim had a peaceful character and can offer evidence that the defendant is the one that has a violent character. Okay? So now I want you to, though, notice the very first part of 404A2B here, this first part, it's the lead-in. And it mentions that this right of defendants to offer evidence of a victim's pertinent character trait is subject to the limitations in Rule 412. Okay, I just want to mention what that's about. We're going to cover that in a few classes, a couple classes from now. Now, Rule 412 is sometimes referred to as the Rape Shield Statute. And what this is referring to is that a criminal defendant charged with sexual assault is limited in what kind of evidence about the victim's character can be brought in, because sexual assault victims are protected from certain kinds of character evidence coming in against them. So that is why this exception here in 404A2B starts with this limitation, reminding us that in a sexual assault case, there are limits to what a criminal defendant can put on. Okay, the next one, 404A2C. Next, now, if we're dealing with a homicide case only, homicide only, Rule 404A2C actually allows the prosecutor to offer evidence of the deceased victim's trait of peacefulness in any case in which a defendant is claiming self-defense, even if the defendant doesn't open the door by offering evidence that the victim was a violent person. Okay, so this is a very limited exception to the general rule that a defendant has to open the door with character evidence. Just by claiming self-defense here, a homicide defendant can open the door to allowing a prosecutor to at least offer evidence of a deceased victim's trait of peacefulness. Okay, and lastly, the other exception here to the character evidence rules, remember, come into play when a witness in any case, any witness in any case, can be cross-examined with specific kinds of evidence that can affect the credibility of the witness, okay, and we're going to cover those all later. All right, so usually I actually don't do this question in class with clickers. I usually just go over it. This is sort of an interesting question that I think would be a great MBE question for the bar. This hypo might test whether your criminal procedure professor did a good job explaining grand jury proceedings, or if you haven't had Crim Pro yet, it's just going to test your basic knowledge of grand juries. But I do think that by the time you get to taking the bar, you will be expected to know about grand juries. So here's the question. Suppose that a defendant in a criminal case calls a character witness who testifies that, in her opinion, the defendant is an extremely truthful and trustworthy person. On cross-examination of the defendant's character witness, now the prosecutor asks, "Do you know that the defendant lied under oath before the grand jury last week?" You know, or a question similar to that. "Have you heard that the defendant committed perjury in front of the grand jury last week?" Is that question permissible? Now, the answer to this question actually requires you to know that grand jury testimony is secret. And since grand jury testimony is supposed to be secret, there's no reason why the defendant's character witness would know about it. So, therefore, this question wouldn't actually serve to test the witness's credibility, right? It's not going to impugn the witness's standards for judging character or the witness's claim to have known the defendant well enough to form a judgment about character. So it wouldn't and shouldn't be allowed. And this hypo was actually taken from a real 1996 Eighth Circuit case with essentially the same facts, where that question was held to have been improper. Okay, I just want to say a few things about the California Evidence Code and our provisions on character evidence. You'll note that there's no California alert at the top of this slide. That is because the California Evidence Code provisions on character evidence reach substantively the same result as Federal Rules 404 and 405, but our rules are written in a lot more convoluted way. We have rules and exceptions to exceptions in our rules. This is a classic example of the California Code being written in a pretty confusing way. So the California Code starts in section 1100 here by stating a rule that, subject to exceptions provided by statute, character evidence is admissible. Character evidence is admissible. It also says that character evidence may take the form of reputation testimony, opinion testimony, or specific act testimony. So this seems completely and utterly different from the federal rules if that's all you were going to read. However, section 1100 is subject to limitations in the sections that follow. And those limitations go about essentially eroding this basic rule of admission getting us basically to a set of rules that completely mirrors the federal rules. So we'll talk about a few of those. So Section 1101A provides that character evidence shall not be admissible to prove a specific act by the person whose character is the subject of the evidence. So no use of character evidence circumstantially to show propensity to commit an act, just like 404A. Okay, then Section 1101B says, though, that evidence of specific acts may be introduced to prove some fact other than disposition to commit such acts. And this is going to include all the issues that we're also going to talk about today in Rule 404B. So just so you know, California Evidence Code has a section that mirrors Federal Rule of Evidence 404B that I'm going to talk about shortly. Section 1102A says criminal defendants may introduce evidence of their own character to prove conduct in conformity with such character, right? In other words, to prove that the defendant's character is not consistent with him having committed the crime charged. And 1102B allows the prosecution to rebut that evidence introduced by the defendant with its own evidence of the defendant's character. Now, if you looked at this, you might have noticed that there isn't anything here allowing the prosecution to cross-examine with specific act questions like 405A allows. And if you just look at the text of Section 1102, it looks like both the defense and prosecution are limited to opinion and reputation evidence to prove character directly. But although the California Code doesn't add the extra sentence that 405A does, specifically allowing prosecutors to cross-examine defense character witnesses about specific acts, like in the federal rule, California case law makes clear that this is in fact allowed under the exact same rationale. The questions about whether a defense character witness has heard about particular past acts go to showing how well the character witness really knows the defendant, and isn't a direct way of proving the defendant's character. Next, Section 1103A essentially mirrors the federal exceptions in 404A to B and C, those provisions we just talked about, where both the defense and prosecution can offer evidence about a crime victim's character. And again, this is usually going to apply in cases in which the defendant is claiming self-defense. That's really when it's going to come up. And Section 1105 of the California Evidence Code sets forth the general rule that evidence of habit or custom is admissible to prove conduct in conformity with the habit or custom on a particular occasion. That corresponds to Federal Rule 406, which we haven't talked about yet in detail. But overall, you can breathe a big sigh of relief, and you can know that the California Code sections on character evidence are the same as the federal rules. Okay, next I just want to briefly talk about this Theodore Roosevelt as a character witness piece on page 121. So obviously a fun piece to read, and in addition to what it tells us about Teddy Roosevelt's personality, it illustrates the problem they had in the past with the previous form of what is now Rule 405A, where they prevented defense character witnesses from stating their personal opinions of the defendant. Remember, they only allowed the witnesses to just report what the defendant's reputation was. And in fact, this difficulty, like I said before, was the reason the rule was eventually changed to allow either reputation or opinion testimony. But you saw that illustrated in full flower here, right? Teddy Roosevelt thought it was absurd to just keep asking him about the defendant's reputation. He personally knew the guy, so he could tell the jury anything they wanted to know about him. Now, this excerpt, I think, also brings up something else that's interesting, and that is whether putting in evidence of good character ever really helps criminal defendants. Now, I've already pointed out that in most cases it's dangerous, and it's done really rarely, right? Because the prosecutor can retaliate, like in the Mickelson case, with questions about specific acts and past convictions and so on. So not done very often. On the other hand, if the defendant has a very good reputation, or especially if the defendant has impressive friends, like Teddy Roosevelt, right, it can have a powerful influence. So I have a couple of other cases that are kind of fun I wanted to tell you about. So the guy in the middle of this slide, Alger Hiss, he's a former State Department and United Nations official who was charged with being a Soviet spy. This is back in 1948. Alger Hiss, charged with being a Soviet spy. He had, at his trial, 2 sitting Supreme Court justices as character witnesses, Felix Frankfurter and Stanley Reed, which probably helped him get a hung jury in his trial. You can't get much better character witnesses than those. Another example here in the center is John Connally, former Texas governor, actually also former U.S. Secretary of the Treasury. He was tried on corruption charges, and he had all of these people on the slide as character witnesses, starting with the one on the top left. That is the famous preacher Billy Graham. Billy Graham was Connally's character witnesses, and he was asked on direct to state his profession for the court, and he answered, "I teach the gospel of our Lord Jesus Christ here and abroad." And one of the jurors apparently got whipped into a frenzy and leaped up out of her seat and shouted, "Amen." And then Connally had other character witnesses, including 2 former cabinet members, Dean Rusk and Robert McNamara, 2 former First Ladies shown on the slide, Jackie Kennedy Onassis and Lady Bird Johnson, and up here on the top right of the slide, Congresswoman Barbara Jordan, who had been the first African American state senator in Texas history. So lots of great character witnesses for John Connally, and he in fact was acquitted in his case. But again, aside from these exceptional sort of high profile cases, conventional wisdom dictates that it's a very big risk for criminal defendants to open this character door at all, because the upside is very rarely greater than the potential downside. All right, I'm going to end this video lecture here.